everyone.
Morning.
With us today for an exciting and educative insertion training, we have with us no other one than Dominic, the CEO of First Aid. If you need any help as an agent, she's the first person to call to. Please welcome with us Dominic with a round of applause.
Good morning, everyone.
Morning.
How was your travels to work today? Quiet, not quiet. I had a bit of traffic. I don't know about you guys.
Most difficult.
So just so that you know, I have a very conversational way of doing training, so that we all stay engaged in the process and support. So I'm going to start with a few questions just to gauge where we are at as a group of estate agents. So quickly, by show of hands, who here has an established rental book already? No one. Are we all new to rentals? Everyone new to rentals? Why is no one responding? do you have a book?
Can you briefly explain to us what a rental book is?
It's just having more than one rental that you manage on a monthly basis.
Yes.
Oh, so you have a rental book, alright?
Yes.
How many rentals do you manage on a monthly basis?
5.
5, alright. I saw you also raised your hand.
I don't know.
You don't have, alright. So is it safe to say that most of you are quite new to the space of rentals?
Yes.
Yes, alright, fantastic. Well, that's great because my training is about the basics today. So I'm going to talk you through the rental process flow, what the must-have documents are for rentals, inspections, and very important, and management versus procurement business. Alright, so we're going to start with the rental flow. So if you look at, I'm going to tell you which page is the right picture one. It would be page 18. So it looks like this. This is the pretty picture rental process flow. You can either follow along through this page or by reading the descriptions from page 3 and on, as I will be discussing that as well. So it's up to you, whichever you prefer. Alright, so when we talk about the rental process flow, it's a lot similar to the sales process flow. Right? So how many of you are active sales agents at the moment? Alright, so quite a few hands. Alright, so rentals and sales are similar in the sense of how it flows. The major difference, in my opinion, as it relates to rentals versus sales, is that rentals is a little bit more legally stringent. So it's more strict, right? So and that's just the major thing with rentals. I always say, if you start on the right foundation with a rental, you can't go wrong. So that's what I'm going to teach you today. So we're going to talk through the flow. So the first step is obviously canvassing for a lessor, the landlord of the property. So while we are doing the canvassing for our lessor, we need to know what paperwork to prepare, right? So I'm not going to teach any sales tricks today. That is going to be my expertise. I'm going to talk paperwork with you today. So first things first, you just as with sales, you need your mandatory disclosure. Alright, so the first thing you want to take with is your mandatory disclosure form. Then you also need, very important, a listing form. What is a listing form? Can anyone describe a listing form? So a listing form is a description of the property in the most detailed possible. So I will provide Michael with a template that you can use in your office as a listing form. You can adjust it to your needs. As you come across, let's say you prefer working with apartments, or you prefer working with freestanding property or properties within an estate, you can alter your listing form to suit your needs best. But a listing form essentially gives the full property description. You find out from the owner the utility details, you put it on that form. How many rooms? How big are the rooms? What's the square meterage? The standard information you would need as for a sale as well. right? So that's what your listing form would then do for rentals as well. So now we have the mandatory disclosure form, we have the listing form. What else can you think of would you need for your first appointment with a lessor? Mandate, very, very important. I think there's a massive misconception in our line of work, especially in a South African context, where the mandate is a second thought. Your mandate for your rental lays the foundation for your relationship with your landlord. What is his expectations from you? What does she want you to manage on a monthly basis? Is it just collecting rent? Do they want you to manage the utilities as well? Do they want you to conduct more regular inspections? You need to find that out and establish that business relationship within your mandate. Your mandate is a written agreement between yourself and your landlord, so that there are no questions regarding what your duties and responsibilities are as a real estate agent for that lessor. Alright, so we have the mandatory disclosure form, your listing form, your mandate. Anything else that you can think of? I'm sorry? Yes, FICA documents. FIC. So the Financial Intelligence Centre Act rules our lives as state agents. So it's always important to start that conversation with the FIC form already, so that you can do your screening and your verification as needed before you officially start that business relationship. Right. So those are the basic documents you need to have prepared when you go out for your first listing appointment with a landlord, so that you can get everything completed as is, right there on the spot. Because we don't want to bring ourselves into a situation where we have to send 6 emails requesting different documents at different points, at different intervals. Get it right from the start. Get it right there, and then you don't have to struggle with it later down the line. I mean, everyone knows that frustration of when you're right at the closing of the deal, the lease agreement or the sales agreement is signed, and now you are waiting for an ID copy. It's a frustration for the agent and for the landlord, right? So let's avoid that. So that's the first step, canvassing for a lessor. Then we need to get a lead on a lessor. So that's what we use our marketing platforms for and so forth. So we prep the documents before we approach a lessor. We have our standard set of documents ready for your area and for the type of property that you prefer to work with. That's why I say you tailor your documents to your needs as the real estate agent. So be prepared before you go out to that first appointment, before you get your lessor, so that you are ready to jump when the opportunity presents itself. Then you verify and screen your lessor. So before you list the property online, before you have the official signing of the mandate, which in practicality happens on the same day, you want to verify and screen according to FIC, right? FIC says we need to verify and screen and identify our clients if they are prospective, meaning before they become our official clients. Alright, you can work out in your work setup within yourself, within your office, if you have procedure in the office for it, how you are going to administer it. I'll always say a TFA screening, for example, who knows that term? Michael knows it well. TFA screening against fixed list online, you can literally do it on your phone in 30 seconds. So while you're at the table at your listing appointment, you can ask the owner for a copy of his ID or a copy of his work permit. You can put in the details as per the ID. You can do the screening on your phone, take a screenshot, email it to yourself. Then you have it on record. Alright. Then you sign a mandate, obviously, and only after you have a signed mandate, a completed listing form, verification and screening done, and a signed mandatory disclosure form, can you list the property. This is very important. Do not list a rental property unless those documents are checked off. I've seen in PPRA inspections where they specifically go onto the portal of that estate agency that they are doing the inspection at the night before, and they pull all the active listings, and they come with that list the next morning and say, where are your mandates? Where are your mandatory disclosure forms? Where are your FIC documents? They check all these things. So it's important to have that in line. Right. Now you've listed the property. Now we are looking for a lessee, right? So the same procedure we would follow for a lessor, we would follow for a lessee. Set the documents that we have ready for a lessee is the details that you've obtained from your listing form. You use to advertise the property properly. We as estate agents have the duty to disclose. So if you know, for example, the property has a leaking roof, or you know there are maintenance issues regularly with the plumbing because the owner disclosed such information with you, or there's maybe an issue with the utility account, or whatever the case may be, whatever adverse thing could cause a material, thank you so much, a material change in a lessee's decision to sign a lease agreement, you need to disclose before you even start the process of the lease. So have that information on hand. So no matter who you take out for a viewing, you can present all material facts to them, good or bad. Mostly bad are important facts, you know. Good is always good. So yeah, so the trick is just to have that ready to disclose before you start taking lessees out to the property. Then you get your lessee. Let's say, for example, they reacted on a Property 24 advertisement. They went to a viewing and they say, I want to sign a lease agreement. That person just went from a lead to a prospective client. Prospective, FIC obligation. So now we need to FIC our client. FIC questionnaire, supporting documents, ID proof of address. Get that ready. Get them screened and verified, and then you move on to the final part, the signing of the lease agreement. Now the lease agreement in and of itself, right, is also the only document that describes the relationship between the lessee and the lessor. Quickly tell me, do you think the real estate agent is a party to a lease agreement?
Is a part.
Yeah, party, one of the parties of the lease agreement, yes or no?
Yes.
It's not, you are not. Remember, your relationship is described through your mandate. You represent the lessor in any lease agreement. You are not the estate agent of the lessee. Yes, the code of conduct says whenever we do business, we need to have due regard for all parties involved. So we don't treat the lessee unethically just because they are not our client on paper. But we are not a part of the lease agreement. We facilitate the lease agreement on behalf of the lessor and the lessee. So we need to make sure as the estate agent that our lease agreement contains all relevant information towards that specific rental. For example, never leave out utility information, because that's the first question that will happen after the first deposit has been paid, the first month's rent has been paid, and the 30 days have gone by. How do I get water and electricity? Is it prepaid? Is it not prepaid? It's a question that can come up, and if you are not preparing yourself from the start of this flow for that question, you won't be able to answer it. So include it in your lease agreement. Include in your lease agreement the owner's expectation for yearly escalation. As we all know, I mean, how many of you personally rent property? I rent property. So we know we get annual increases, right?
Yes.
Do you know if it is contained in your lease agreement, a set percentage, or do you expect it to match CPI? Do we know? I never check. And then when the escalation comes and I get the addendum, I quickly check that isn't in line with what the contract says. So inform your lessee before they sign on the dotted line that they can expect an annual increase in rent for whatever percentage the landlord is comfortable with. That you have determined in your mandate already. So you don't have a question as the estate agent. You can prepare the lease agreement in full because your mandate set you up for success. Alright, so your lease agreement, like I said, is the only document that describes the relationship to the lessor and the lessee. So it's very important to be very diligent when drawing up your lease agreement. Don't leave anything up for interpretation. Alright, so once the lease agreement is signed, we talk about finalizing the transaction. So finalizing the transaction essentially means that for a lease agreement to start, it is not as with a sales agreement, whereby the signature on the dotted line means the relationship commences. There's a performance that needs to happen first. What is the performance? The deposit payment. So usually, most companies are set up in a way that to protect the landlord, you expect the lessee to pay first month's rent, deposit usually equaling a month's rent, and whatever application fee you as an office deem fit, or credit check fees or whatever you require. Alright, so those steps need to be taken. They need to make the deposit into the trust account of your business or into the account of the lessor, depending on what type of agreement it is. Alright. Then only can we say that the transaction is finalized once we receive the funds, because that starts the obligation in terms of the lease agreement. It's not the signature on the dotted line. That's a major difference between sales and rentals, right? Sale agreement, once that signature is there, if there's not a suspensive condition, the contract is the contract. You can't get out of it. With lease agreements, the payment's not made, the contract doesn't start. Alright. And then ongoing due diligence essentially means if you are doing a maintenance rental, which means you assist the owner in getting the monthly rent into your trust account, you deduct your commission, you pay out the rest to the owner. That's a maintenance lease, meaning you as the estate agent is involved on a monthly basis to pay the owner what he's due and collect from the tenant. Alright, so that's what a maintenance lease is. Obviously, if you are doing a procurement lease, which means you are just placing the tenant, you are not going to do ongoing due diligence. Alright, you're not going to be involved in that transaction every single month. You place the tenant, you got your fee, and you move on. But we'll touch on that subject a little later. Alright, so that's the basic process flow for rentals. You are welcome to read the nitty-gritties of the sections of the Act that I've included for you in your packet, but I think it's better if we move on to the must-have documents for rentals. That starts on page 12. There we go, page 13. Alright, so as we have discussed, these documents we gather at different stages of the lease agreement process, right? So the first, obviously, the most important document in terms of a lease is the lease agreement and its relevant amendments. Then the mandate is very important. The fee questionnaire for the lessor and the lessee. The fee accompanying documents, meaning the ID copy, the proof of residence, and so forth. The mandatory disclosure, the application to rent, I'll touch on that just now, and the completed inspection. So, what is an application to rent? Yes, for the tenant, the lessee, ne? Right, why are we wanting to complete an application to rent?
Just get all their credentials and see if they qualify from the
See if they qualify. So the important thing about that is we have a responsibility as an estate agent to not just place any guy off the street in our landlord's property. We have to be prudent in suggesting options to our landlord to say, I have deemed them creditworthy, these three applicants or these two applicants creditworthy. Here is my evidence of such suggestion. Make a choice on which one you would like to place. That's another big tip I would always like to give you. Never make the choice on behalf of the owner on placing a tenant. Because imports will come up You know, I always say, you plan for the worst and hope for the best. Planning for the worst means don't make the choice on behalf of the landlord. Present them with an option or two and tell them, here's my evidence to say they are creditworthy. Here is their application form. Would you like to place them, yes or no? Because if you're in court and there's a dispute, the tenant suddenly stops paying, what's the first thing the landlord is going to do? It's your fault. You place the tenant. You want to avoid that situation, right? So never make the choice on behalf of the landlord, right? And then some other documents that you can have as well is the rental summary sheet, which is like a sheet you put in front of the file just to summarize the rental details. If you have it in your office, if it is within an estate or a sectional title scheme, include the complex or HOA rules. Alright? I see a lot of estate agents usually end up forgetting this. Presenting those rules, especially when it comes to, for example, pets. Right? Do you know if you are working within an estate, what's that estate's rules regarding pets? Now you place a tenant, they didn't ask because they follow the don't ask, don't tell rule. They have 3 dogs and 4 cats. The complex only allows 1 small animal. Now they all of a sudden have already signed agreement, paid the deposit, now they must get rid of their pets or move. So make sure you have those rules well in advance if you're working within a sectional title scheme. And present it to the lessee before they sign the lease agreement, alright? So those are the documents, and then key handover form. This is just something I always like to do. When you are handing keys over to a tenant, right? There are keys for the front door, the back door, the gate. The garage has a remote. The bathroom has a key for some reason, but some of the rooms don't. Make a log sheet of the keys that you hand over, so that when it comes time, when the lease agreement ends, you make sure that they return the keys of the property. So even if you have copies of the keys, if you give them 2 copies, 2 sets, make sure that you make a note that you've included this list of keys and they have 2 sets, so that they return everything. Alright. For security reasons, for due diligence reasons, the landlord then trusts you more because you have a very diligent list of keys that will be returned. So they know it will be returned, or the tenant will have to pay at the end of the lease agreement to replace whatever was lost. Right. So now let's talk a little bit about inspections. So who here has done a property inspection in terms of rentals before? Have you done it? Done? How do you find the process? Is it a quick process usually for you? Does it take a bit of time? It takes time. Why does it take time? We want to be as thorough as possible. Take photos of everything. If you see a crack in the wall, take a photo. Note on a piece of paper the photo. There's a crack on the wall in this room on this wall. And then when you build your report, you include the photo and the description. So that at the end of the lease agreement, you don't end up in a situation whereby it's a he said, she said situation. You never want that. You never want the landlord and the tenant to fight over whose fault was what. Right? So we get 4 types of inspections. So when you go out to your listing appointment for the first time with the owner, I always advise my estate agent that they're going to do a preliminary inspection with you. This one does not have to be in detail. This one you don't have to necessarily take photos of. The purpose of this one is for you as the estate agent to figure out, firstly, are there any noticeable maintenance issues that you can see that would probably be able to be fixed or need to be fixed before someone can move in. For example, if a house does not have hot water, can you in good faith place a tenant? No. You cannot. If you see that half of the lights in the house is not in working order, can you place a tenant? You cannot. So obvious maintenance issues we try to point out, and we ask the landlord, is it possible for you to fix it? so that we can then get it fixed before we start listing the property. Yes.
I'd like to ask, do we do the mandatory before or after this preliminary inspection?
Everything together. So everything lessor wise. I always try, like if we talk about in a practical sense, right? You can't necessarily start doing paperwork without going to the property for the listing appointment, you know?
Yes.
So I like to do everything at the listing appointment.
Okay.
So you sit at the table and you do the paperwork. Before they sign the mandate, just do a quick walkthrough of the property with the owner. And they tell you about the property. Why are they renting it out? What's their idea? Are they going to sell it in the future? Have a nice conversation with them. Get to know them while you are doing the walkthrough of the house.
Well, in other cases, our owners are not in Pretoria or do not live anywhere near their property. So we have a thing where they haven't seen their properties in years and they're getting the information solely on us. You know, so how do you do it in that?
Then I would suggest doing a full inspection when you go out to take the photos for the listing purposes. That would be my suggestion. If you are in a situation whereby the landlord is not in a capacity to go take you to the property themselves, make sure that you then do a more thorough preliminary inspection. Because then you are their informant, essentially, on the condition of their property. And you would like, as the estate agent, to as soon as possible place a tenant. And you cannot do that if a property is not in a condition to do it. So that would be my suggestion, alright. Then you get the moving inspection. So as the name suggests, this happens on the day of movement. When you do the key handover with the lessee, this inspection you must do with the lessee. This is the one now when you take all the photos. So before they start unloading the boxes from the car, you do the inspection with the lessee. You walk with them through the property, tell them what you notice, so that they notice it as well. What I usually like to do is after that inspection, I hand them an empty inspection form. And I say, within the next 7 days, so after 7 days that you've moved in, return the form to me. Because you will probably miss things, and they will most likely also pick up on things that were missed during that first inspection. But it forms part of the move-in inspection. So you hand a completed move-in inspection form to your lessor and your lessee after 21 days of moving in. So before the second month rental is due. So you combine those two there. If there's something you missed, or something the lessee missed, or whatever, then you can get on the same page with that final inspection report. Now remember, this inspection forms the foundation of any damage claim at the end of a lease agreement. So this one you need to keep proper records of at all times. You cannot throw it away, it needs to stay in your files, because if any dispute arises as it relates to the deposit, this will be the inspection that the rental tribunal will refer to. Alright. And then also, yes.
So question about the move-in inspection. In other cases, there are tenants that would like to move in when it's less busy on a Sunday evening or Saturday night. Then how, because you do it usually when the key handover. So would you do this before that? Okay.
The idea is to be able to do it with an empty house. You know what I mean?
Yes.
So if the property is, let's say, empty for a week or so before they have to move in, try and schedule a date within that week. If after hours fits for them, then you go do after hours to do that inspection with them before they start doing furniture everywhere. Alright. So then we can also get what we call a quarterly inspection. Now this is for those of us who strive towards the highest standards of ethical and professional behavior. So not every estate agent does quarterly inspections. Why not? Because it's a lot of work. But why do we do quarterly inspections? Quarterly inspections are done to check two things. Firstly, is the tenant breaking down the house without your knowledge? That's an important thing. The amount of closing inspections or move-out inspections I've attended where the state of the house is unrecognizable from move-in to move-out is staggering. You would be surprised what people can do to a property while living in it. One of the things was I will never forget it. The tenants were living there for 2 years. Most beautiful kitchen. It was done. It was brand new when they moved in. New stove tops, beautiful cabinets, marble counters, beautiful white cabinets up to the roof. When they moved out, that whole kitchen was yellow brown from oil that stuck to the cabinets and to the roof. It looked like no one took a cloth to anything in that kitchen for 2 years. It was horrible. We had to get professional cleaners to come remove it because not everyone knows how to clean 2 years of oil buildup. And that's expensive to hire people there to do it. So quarterly inspection, you would have caught it. So those are the kinds of things that we pick up in a quarterly inspection. We don't have to take our camera necessarily along. We can use our phone if we pick up something that's important for us. For example, you see all the cabinet handles that we removed in the kitchen while they were living there. You can take a quick snap, ask them about it later. Tell them, are you aware that you need to replace what you have taken off before you move out? Yes or no? If they say no, then you can have that conversation in the meantime. So don't wait until the end of the lease agreement, when now we have to deduct thousands of rands from their deposit because they weren't aware of their obligations. All right. So that's what a quarterly inspection does. And then also, for example, if the occupancy limit of the property is 4 people and you walk in and there are 15 people, all of a sudden, where's everyone sleeping? A landlord usually have an occupancy limit for a reason, not just for maintenance purposes, because wear and tear is much higher with the number of people who live in the house versus lower, right? So that's another thing. And then lastly, we get a move out inspection. Now, move out inspection, yes.
Yes, I just want to find out. Let's take, for instance, you do that inspection, then you find a huge damage in the property. And you do the quotation, and then you say to the see that this is what is going to cost you to fix. And the very same person say, I don't have that money to fix. Why are you doing?
So there are differences in what would be the landlord's responsibility and what would be the tenant's responsibility. So let's talk about that for a second, because that's going to help answer your question. So the landlord's responsibility is what? Structural, so roof, windows, doors, basic water, so hot and cold water, lighting, except if a light bulb goes, like if it's electrical, hidden. That's the landlord's responsibility, and general wear and tear. Meaning we all know the hinges on a cabinet door, for example, after 2 years, 3 years, they start not working well, right? That's for the landlord's account, it's not for the tenant's account. But if we are talking about the kitchen was newly tiled and all of a sudden 4 of the tiles are cracked when you go for a quarterly inspection, that's not general wear and tear. A tile doesn't crack just because. You know what I mean? That would be for the tenant's account. For example, the pool pump. If you move into a property with a pool and it has a pump that you have to then maintain as the tenant, meaning you have to do the pool maintenance. So if the pool was given to you in a state of working condition and the pool was blue and the pump was working, if that pump breaks and it has a warranty of 5 years, and the company that put in the pump can prove that you were negligent in using the pump, you need to then replace it as the tenant. If it's a factory fault, it's a factory fault. Then it will be addressed either by the landlord or the company that installed it or whatever. So it depends on who's responsible for what. If a situation arises whereby the tenant says, or the tenant, let's say, they drove through the garage door. That's an expensive fix, right? That's going to be at least 8K for a new door that doesn't take into account the mechanics behind it and whatever. They drove through the door, so it's their negligence that caused the damage, and they say they can't pay for it. Then you have to then make an arrangement with them, or they must make an arrangement to say they'll either, you ask the landlord to say the landlord will, let's say, pay it out of the deposit for now, and then they have a responsibility to, within 6 months, replenish the deposit. That's a good example that you can do. But that has to be in writing always, because the moment you touch the damages deposit during the lease agreement, that has to be in writing, and the lessor and lease invoice needs to sign. Another example is you can tell them, sorry, but you have to take out a line of credit, because it's not the landlord's responsibility, and you need to return the property to its original condition immediately. It is what it is, yes.
Politics. Just wanted to ask, based on some of this information, I had a question about the rental share. I
Yes.
wanted to ask, which events could lead to that clearing and consumption in an empty must be to call?
Now, let's talk about the rental tribunal. So the rental tribunal is a tribunal that was established in terms of the Rental Housing Act. So the Rental Housing Act is an amazing thing, especially for the estate agent, to determine the relationship between the landlord and the tenant. Think of it as basic conditions of employment act, but for rentals. So it sets the minimum standards for the expectations of landlord and tenant behavior. So the rental tribunal is regionally based. So in Gauteng, for example, we have 4 tribunals. You can Google the rental tribunal and get the information for your area in which your rentals are. So that you have that contact information. You can approach the rental tribunal. They are mostly used for disputes regarding deposits. That's their biggest sort of caseload. But you can approach them for anything regarding your lease agreement. If there's a dispute on anything, you can take it to them. So you as the estate agent are actually not involved because you are not a party to the lease agreement. So if the lessor has an issue with what the tenant is doing in their property, they make the complaint to the rental tribunal. They set a case, they set a date. Both parties need to show up for that meeting, and then it gets settled through a mediator. But you as the estate agent can facilitate the process. So you can help them download the platforms, help them complete it correctly, help them add it in the correct manner. So the rental tribunal is a fantastic tool because it's completely free. And it's fast. It's not like the High Court or even small claims court where you can wait months up to years for dates. It's within weeks usually. And I always say, if there's any dispute regarding a deposit, don't try and sort it out yourself. Have the professionals do it. Go to the tribunal. Approach the tribunal. Alright, it's a fantastic tool. It feels like the best kept secret in real estate in South Africa is the rental tribunal. I've only had positive experiences. It's fantastic. It's like the CCMA on steroids. It's great. I love it. Any other questions regarding the tribunal? None. Alright, so now we've talked about inspections. Lastly, I want to pull your attention to what the difference is between a procurement and a management lease. So that's the table on page 16. So the major difference in what a management and a procurement lease is that with a procurement lease, your job is to place the tenant. That's where your responsibility is. So let's read through what you need to do under both maintenance and procurement leases. You need to do the advertising and marketing. You need to do the mandate, the FIC docs, the affordability checks, the placement of the lessee, compiling all needed documentation for the lease agreement, invoicing for the first month's rent and the deposit, that will still be your responsibility, the move-in inspection, sending all contract documents to the relevant parties, and the key handover. That you will do regardless of if it is a maintenance or procurement lease. Now, the difference comes in. With a maintenance lease, you will still be the one invoicing the tenant monthly to say, please pay your rent into our trust account, we will pay the owner of the deducted our commission. That's one of the major changes. Sometimes you will find, this doesn't happen often, but I've seen it happen, where the owner prefers that they are the one who still gets the monthly rental, but you are still responsible if any maintenance issues arise. Now, I'm not necessarily comfortable with that because then you don't have any control. money is control. Right? We want to maintain the control as the estate agent. The moment the lessor and the lessee get too comfortable around each other, you will see yourself disappearing without even noticing. So never go for an option like that. Also another tip, if the owner ever asks you, even with the procurement fees, ever asks you that they want a deposit, your answer must always be no. Deposits are trust monies, meaning it's not ours, it's not the landlord's. You're keeping it safe for the lessee. So is the owner aware that if the deposit gets paid over to their account, even with the procurement lease, that must be interest bearing? Are they aware that they cannot use that money for anything else, it must stay in their account? Are they aware what the responsibilities are of what you can deduct and what you cannot deduct? You see what I mean? Try and always keep a deposit in your trust account, because then you know it is safe. Alright, even with the procurement lease. Then you do not do the monthly rental invoicing for procurement lease, actually for management lease. Maintenance queries, if you are managing the lease, you are responsible for the maintenance queries. The owner wants something fixed, if the tenant wants something fixed, you need to raise that. You are the one getting the quotes from the suppliers and so forth. With the procurement lease, that's not your responsibility. Quarterly inspections, you do that with the management lease, you don't do it with the procurement lease. That's the owner's responsibility. And then obviously the move-out inspection. For management lease, that's your responsibility. For procurement lease, that's not your responsibility. Now, how do you think is a good way to maintain the relationship with the landlord if you've done a procurement lease? Meaning, what are the chances, for example, that they will use you again when 1 year has lapsed and that tenant either stays on that you placed, meaning you are then due commission again, or they want to place a different tenant? How do you ensure that you keep that relationship alive? Once every 3 to 4 months, when you would have done a quarterly inspection, get in contact with that landlord. Are you still happy with your tenant? Are they still paying on time? Are there any issues that have arisen? We don't do that because we get paid for it. We do it for future payments. Because legally speaking, as long as that tenant is living in that house, you are always due commission when that lease renews. So the difference between a maintenance and a procurement lease in terms of commission is with the maintenance lease, you get monthly commission based on the rental amount. So let's say the rental amount is 8,000, your commission is 10%. That's usually what it is for a lease, right? So you get 800 rand and that gets deducted monthly from the owner's account. You get it monthly in your bank account after the office has deducted what they need to do. With a procurement lease, it's a one-off payment. And it's usually a little bit more like a sales commission. So it's usually 7.5%, so it's a little less, but you get the whole year's commission up front. So that's the major difference in commission. So the procurement lease is if you are a sales agent at heart. You don't want to be involved with the monthly nitty-gritties in terms of maintenance, whatever. Procurement lease is your better option. And it's also a nice sell, you know. You can explain to a landlord that it's like a recruiter. That's essentially what you are. You are a recruiter for tenants. Place in and you move on with your life. You want to keep getting commission though, so make sure to have those regular conversations. So those are the major differences. So do you have any questions regarding the difference between a maintenance and a procurement lease? Yes.
What I was saying, procurement also, we keep the deposit, even if we place them once. And then if the tenant moves out after 2 years, we must be reminded of the deposit in 2 years.
But if you have the proper systems in place, it's an easy task.
Is it?
It's an easy task. What rental system do you use currently, Michael?
TPM.
TPM. You can set up reminders on your Google Calendar, you can set up reminders on your TPM, whatever the case may be. There are places you can set yourself reminders. Don't let a contract leave your desk without knowing when your action dates are. What is an action date? An action date is whenever something has to happen. So whether that is when your inspections will be due, whether that is when you need to start asking about escalation addendums, when you need to start asking about those questions. Don't let the lease agreement leave your desk without marking all of your dates for that lease agreement in your calendar. It is very, very important. Alright, so that's all I wanted to say today. Any questions? Yes, Mike?
Okay, the situation whereby you have a deposit in a company, okay, and then tenants keep 1 month rent. Here is the owner who absolutely depends on this income to pay their bills. And now their demand says, can you please give me that deposit? Let me offset my bills. What do you do?
Okay, so technically speaking, that is not legal, right? In terms of the Rental Housing Act, but I'm going to give you a loophole now. So in terms of the Rental Housing Act, you're not allowed to use the deposit for literally anything but damages. Potential damages. You have to prove the damage, right? But the Consumer Protection Act states, if the situation arises whereby the contract is cancelled, I'm going to talk more about that just now. Cancellation terms. So if the situation arises where contract is cancelled, you, for whatever reason, the owner is entitled to a reasonable penalty, usually equal to 1 month's rent. So there's your loophole. But it is then imperative that if the tenant's rent is due on the 1st, you send a notice on the 2nd to say that you have paid late, you are on notice. You put them on a 7 or 21-day notice to say you have 7 days to pay your rent. If those 7 days have gone by and they have not paid their rent, they are in breach of contract and the penalty under the CPA gets applied. So there's your loophole. It's important to know those cancellation terms and what your action should be as the estate agent. So yeah, so that's basically my 2 cents. Any other questions?
So if the landlord takes the deposit, they then owe you that deposit. So for the next following month, you'll be expecting payment from both maybe the owner and the tenant. The tenant will pay their rental amount that is due, and the owner will have to also replace that deposit.
I would say keep it. Yeah, it's a little bit difficult to sort of administer. I would always say rather withhold than expect payment.
Okay.
You see what I mean? Instead of paying them out their monthly rentals in the next month, explain to them once you make the payment of the deposit that next month will be withheld if you get the money from them. So that they will be in a deficit until the end of the contract unless the tenant catches up on payments. That's just the short and long of it.
Yeah.
They should be aware of that before that deposit gets paid out. And also remember, as I explained, a deposit should not be touched unless a landlord and a tenant has agreed to it. So if you are in a situation whereby you are using the deposit for rent, there must be a written document to state that is what is going to happen, and both the landlord and the tenant must sign that document. No one should ever be in a situation where they are not aware of where the deposit is. Right. You had a question.
Mine is similar with, let's say you're inheriting tenant. You've signed a meeting with the owner. Now you inherit tenants that are not paying money. So for the owner, they are hoping that find means to evict them and then get your own tenants. That will be vetted. Looking at the fact that at first when they got the tenant, they didn't vet them, they just took them. So now they are not paying. So under Housing Act, the Rental Housing Act, how many days is it legal to issue those eviction notes.
Those letters of cancellation. Okay, let's talk about that. So in terms of that, there are two laws that we always have to look at: the Consumer Protection Act and the Rental Housing Act. So the first thing we need to determine is, when does the Consumer Protection Act apply? The Consumer Protection Act applies if it is a fixed term contract, which all rentals are, because it's for a month or a year or 2 years, whatever, fixed term contract, and one of the two parties is a natural person. Both can be a natural person, but at least one must be a natural person. Then the CPA applies, which means, unfortunately, in terms of cancellation terms, that you have to give 20 business days notice. So, you have to tell the tenant, first you have to put them on notice, you have to say, you are late with rent. As per this clause in the contract, if they sign the contract, even if it was a verbal agreement, the rent was expected on the 1st, you are late on the 2nd. You are hereby placed on terms, meaning you are in breach. You need to remedy your breach of contract within 20 working days. Once those 20 working days are over and you have not received one single cent, you can immediately cancel the lease agreement with 7 days notice for them to move out. That is if the CPA applies. If you are under a circumstance where the CPA does not apply, meaning let's say the contract has lapsed, they didn't sign the new agreement, which means it's automatically a month to month, which is not a fixed term contract, so then the CPA does not apply, or both parties are not natural persons, meaning they are businesses or whatever the case may be. Then the CPA does not apply. Then you can apply 7 days notice of breach, and then as well 7 days for cancellation. If they do not vacate the property on the date stated on that second notice that you send that they need to move out, you take it to your court. It sounds like it's a long process, but it is an abbreviated process because you don't physically have to go stand and appear in court. The judge gets it on his roll. He does, I don't know what the official term is, not ask. But they do like an abbreviated thing. They write a little thing to say, hereby you are noticed, the sheriff will come and collect your things within 7 days if you do not vacate the property.
But when you answered, you did say that it's one person has, at least one of the parties has to be a natural person. If both are juristic, then what?
Then the CPA does not apply. Then you have 7 days instead of 20 working days.
Okay.
So your notice period is shorter, your breach period. You say, your first notice that you say that you are in breach of your contract, that first notice is shorter. So that's sort of a good thing. The CPA does not apply.
Okay.
But yeah, so those are the two sort of things you need to take into account. Yes.
So, what would the goal be to evict if it was a member that it was
But then it's not a fixed term contract. You can never argue a fixed term contract if it wasn't in writing. So then the CPA will not apply. So then you can use 7 days notice. Alright, so that is a quicker process. So you give them notice of breach of agreement. The verbal agreement was your rent was due on the 1st. It's not a fixed term contract. Pay the money in 7 days. You mark on your calendar as the estate agent 7 days from that date. You give them their second notice to say you have notice to vacate. You need to be out of the property within 7 days. If those 7 days have lapsed, you contact your favorite attorney, to write a letter to the court to ask them to enforce the vacancy notice. The court issues the notice, the sheriff drives to the house within 2 weeks, so it should not take longer than a month or so to get the tenant out if the correct process is followed. What do we never want to do when it comes to evictions? We never want to go change the locks. We never want to break all the windows, get random people to move into the property. That is called spoliation, and that is very much illegal. If the court is ever approached in a lease agreement where a lessor did spoliation, the tenant will always win. Always win. Because it's essentially like, I don't want to use the word discrimination, but they are treated unfairly, you know? Yes, they have not paid their rent, but it's still people, you know what I mean? Imagine. You come home and now you cannot enter your house. How must that feel for you as a person? we must never forget our humanity as well in the process. Money can frustrate, especially lack of it, but we must remember that we are dealing with people. Yes.
Is it still a spoliation if a tenant didn't pay their rent and they usually use the money to pay the rent to pay the utilities? So since we didn't get their rent, the rent gets cut.
Yes, you have to as a landlord. Unfortunately, this is one of it's like the bane of my existence in rentals. I hate this because I think it's unfair towards the landlord. But you have to make sure that they have access to water and electricity at all times. So if they fall behind on the payments, you have to, as a landlord, pay it out of pocket. But keep note of every cent, because you can claim it all back either from the deposit or through the court system.
And then,
Right, I know it sounds so unfair, it's so stupid, but unfortunately it's one of those things. That's why you want to get them out as soon as possible. Yeah.
Adding on to that one, in the situation whereby, remember that as agent, we are mediating the process between the owner and the tenant. So let's say we find a situation whereby the tenant is not paying and the owner is the one suggesting that let's cut the utilities. How, in that situation, how then do we become safe in the hands of the court?
I'm with you. So your responsibility is to act as your code of conduct, right? So that's what you're going to do. You're going to advise the landlord. If the landlord does not agree with you, so you tell the landlord, Mr. Landlord, you are legally not allowed to cut the utilities while they are still staying there, whether they are occupying your property illegally or not. Because remember, the moment you give them a notice to vacate, and they did not vacate, they are a squatter. So they are illegally on your property. They still need to have access to water and electricity. You advise the landlord. The landlord then says, I don't care what you say. I'm going to cut the water and lights because it's going to get them off my property. Just have it in writing that you have informed them. So your side is clear. So that you can say, here is the evidence. Whenever a court date appears or you need to testify or act as a witness or whatever the case may be, you can then say, here's written proof. I did my job. I advise them that acted against my advice. Any other questions? A lot, I love it. Yeah.
Yes, I was asking, in terms of a building has been hijacked by the tenants, which process failed? When they can then really one of the subjects, because I've seen sometimes a building has died for 5 years.
I saw something in the news about it over the holidays as well. It's an interesting case because you still have to follow the legal eviction process, even if you never had a lease agreement with these people who are hijacking your property. So it's interesting. I also saw it in the news for the first time over the holidays, and I also read into it, and unfortunately you still have to follow the process. So the CPA wouldn't apply. It could be under the Rental Housing Act, and you would follow that. The 7-day notice, give them notice to vacate the property immediately. You don't have to wait 14 days, luckily it's just the 7 days. But that's the only way. Have the sheriffs remove them. Don't try and do it yourself. Yeah.
Yes, I just want to understand about the placing of tenants. I heard that you spoke about choosing landlord must choose. It must be under the mandate or it must be communicated as we.
Just have it in writing on email. WhatsApp or whatever official writing, like written communication with you, so that you didn't choose it. I usually do it on email. What I do is I send them, or you can go sit in front of them, but just then write an email afterwards to say, as discussed, this is the tenant that you chose. So if you're only sending an email, say here are your 2 or 3 options. Please choose the tenant. Or if you're doing it in person, give them the options in person. Talk to them about it. If they want to know more, you can tell them more about whatever they want to know. And then afterwards, just send an email to say, as part of our conversation today, just want to confirm you chose this tenant. just to have it in writing. You see, prepare for the worst and hope for the best. Yes.
I just wanted to know, let's say now, you see, at this point, you can't make the bill to come directly to you as an agent. The bill goes to the owner, maybe for example, for you. But the owner never sends the bill to you and you keep reminding them, can you send me the bill, can you send me the bill, and they don't send the bill at all. And the tenants can't pay the water because they don't know how much they use,
Yeah.
how much they use.
So what I would do, is it a situation whereby everything is on one Swane account, or even if it is split, the owner still gets both? So what we used to do when I was still working in a rental office time ago, we would ask the owner for his eSwane login details to then link that specific account. Even if he has 7 properties, you don't get access to all 7. You link yourself to that one account, so that on Michael's eSwane account, you can link that account, so that you have access to it as the estate agent. And then you can go monthly, draw the account, send it to the tenant. That's a suggestion. The other suggestion would be to have an affidavit completed between the lessor and the lessee to say that the lessor gives permission for the tenant to receive the account at the address of residence. So that would be a delivered account. But Swane is unreliable, notoriously, so you will maybe get an account once every 6 months. Another suggestion would be, if the tenant says that their average usage is about, let's say, 1,500 for water each month, that's a lot of water, but in any case, 1,500 rand, then just have them pay an estimate. Just so that it is paid, because paying the Swane account is easy. As long as you have the account number, which you can have if you have one copy of one account in the in the past. Have them pay an estimate monthly, and then the owner will then, if the money is less, I can guarantee you the owner will reach out to say, give me more money. So that's another suggestion. So those are a few options you can utilize to try and facilitate it a little bit better. Alright. Yes.
When it comes to some tenants that are owning property, and we have the tenants, the owners that are relentless about receiving the rent, and they, threaten, what, if you cannot handle this, I will cancel the contract with the agency. So in terms of salvaging that relationship you have with the owner, is it possible that you move the tenants from their property to maybe another owner's property, knowing full well that maybe they cannot pay, but that owner maybe would not mind, or is maybe managed by the company, and we know that we can be able to maybe salvage the situation? But
There's always ways. You can, as long as proper procedure is followed, as long as proper cancellation is given to the owner that's losing their tenant, so that they have more than enough time to find another tenant, so that they are not financially disadvantaged by your choice to move the tenant. You can do it. Just follow proper procedure and you can do just about anything. Except spoliation. Don't spoliate. Any other last questions? I'll take 2 more if there is, and then we'll conclude our session today. No more questions? Yes?
So if you say now, you are not managing for the owner, it's a once-off, just giving the tenant and handing over the tenant. When is it advisable to hand over the tenant? For example, you get a tenant, and when the tenant moves in there are so many things that needs to be fixed. And the tenant is saying that I don't want to be handed over unless we keep these things as fixed.
That's why if you check on that checklist on page 16, 17, what page is it? Page 16, right? You need to ensure that you follow all the steps leading up to key handover, so that situation with the owner. So that you and the owner are well informed of any maintenance issues, because you did the move-in inspection, regardless if it's a maintenance or procurement lease. So that the tenant is aware, you are aware, the owner is aware, before you hand over the keys. Key handover is the last thing you do on a procurement lease. So if you followed your steps from A to Z, the foundation is laid, chances of that happening is very slim, almost none.
Okay, let's say for example, I understand it, but there is a tenant that is currently staying there, maybe moving out this end of the month, and then someone is insisting on I want to move immediately, and the tenant that is staying there, the owner is telling you that I want this person out because they are within my property. I cannot fix while they are still inside the property. Because even if I fix, they will damage it again. And then you have another person who's
Yeah, I would suggest to then speak to the tenant that's moving in to say, listen, the owner will need 7 days or 14 days or however long it will take realistically to fix the property. I understand you want to move in as soon as possible. Is it possible for you to live in conditions whereby repairs are being made around you? Yes or no? If they say yes, have it written that those 7 days will be used to repair damages and have them moved in. The inspection will be a little bit complicated because you need to keep track of what is being fixed, and as soon as it is fixed, you need to go and take photos of what was fixed. But then you can have that agreement, it's fine. Once again, almost anything is possible as long as you just follow the normal procedure. So it's definitely possible, it can happen. But that tenant then needs to agree. If that tenant does not want to agree to the damages being repaired while they stay there, they either need to concede that they cannot live there then while the repairs are made, or they need to walk away. They can't have their bread and eat it too. You know what I mean? You can't have bread buttered on both ends, can't have their cake and eat it too. It's just not how that works. They need to also be realistic.
okay, now we fix everything, right? But if the tenant is saying, I don't want to live with this owner, I don't want to pay to this owner, I want to live with the agency. But the argument that we have with the owner is that we just get to the tenant and we give the tenant, but I don't want to work with the owner.
Then you tell the tenant, unfortunately, the agreement that you signed is with the owner and not with us. They have to follow the contract. If they are so uncomfortable with that landlord, then cancel the lease agreement. Explain to them the process of cancellation. Say, sorry, I cannot assist you in this manner. The lease agreement is a procurement lease. My role ends when I hand you over the key. Your relationship, your contract, your paperwork is with the landlord. If it is untenable for you with that landlord, for whatever reason, you are welcome to give notice. 20 working days under the CPA and cancel that lease agreement. Unfortunately, there's no other remedy. They either need to live with it or they need to leave. What else? You can't, unless the owner is all of a sudden willing to do a maintenance lease, but you've already been paid your commission up front. Now you have to do work for free. Because now you received your funds, but it's less than what you would have received if you received it on a monthly basis. So you are losing as the estate agent. I wouldn't do it if I was the estate agent. I wouldn't do it. I wouldn't change it from procurement to a management. Just for tenant's sake, I wouldn't do it.
So would you advise that when a tenant is coming to sign a lease, you would tell them on the spot that we are not managing this property, it's managed by the owner, or maybe wait until they move in, you've not done the...
Be upfront with it. Remember, disclosure, disclosure, disclosure. So before they sign any lease agreement, when they go for the viewing, hey guys, just remember, this is a procurement lease, meaning I am only going to place tenants that you will deal with the landlord directly, but you will get your jobs to be there. You will have a formal introduction or whatever. So be completely upfront with it from the start. But because once again, you've determined that in your mandate with the owner before you even register the property. Right. Any other last question? One more. No question. Thank you so much, guys. It was a very engaging session. I feel like in the beginning you were all shy. You all came out of your closets. So I'm very excited for that. If you have any questions, post them on email through Mfundo. Hey? Yeah. Were you the one I was WhatsApping with? Look at that. I even remember your name and I'm bad with that. Post it to Mfundo. I'll answer them electronically for you if you have any other questions otherwise regarding rentals. Alright. Okay. Thanks for your time, friends.
Thank you so much.